You're listening to Legal Sounds, practical advice for SMEs, the podcast from Davis Blank Furness.
Hi, welcome to a new business podcast series from Davis Blank Furness, one of Manchester's longest established and friendliest law firms. I'm Andy McNish, a solicitor and partner in Davis Blank Furness. I've 35 years' experience of helping business owners navigate all sorts of legal issues and will be your host for the next 30 minutes.
Today we're going to discuss terms and conditions and other commercial contracts. In the main, we'll be looking at it as if you're in a position where you've been sent by the other party to a transaction, their set of standard terms and conditions or a long contract, and you want to have a look at it. But the points we're making would also be applicable if you're the party that's seeking to impose your preferred terms upon the contractual relationship. To assist me, I have Lauren. Would you like to introduce yourself?
Hi, my name's Lauren Sever. I'm a partner in the corporate and commercial department, and I deal regularly with drafting and also reviewing terms and conditions and commercial contracts.
And as the other guest, we have one of our heads of department, Andrew Ryan. When I went to ask him to attend, he said, I'd be a very poor lawyer if I couldn't argue my way out of that. And here he is to help us this afternoon.
Well, I failed to argue my way out of it. So my name is Andrew Ryan. I'm a dispute resolution partner of many, many years. And I spend most of my days arguing about whether terms and conditions work properly for what the client wants or trying to get out of them or get out of the terms. So I think my role today is to look at what happens when things go wrong.
Indeed, and I suppose our role in the corporate department is trying to prevent things going wrong. So let's see if we can manage to do that. So why are terms and conditions important, I suppose, is the first question. They set out the legal basis of where one party supplies goods or services to another party. And we're talking here about business to business. There's special rules that apply in consumer contracts, but for the purposes of this podcast, we're going to concentrate mainly on business to business matters. So terms and conditions, I suppose, what Lauren, would you say are the key points you need to cover or look at if you're looking at somebody else's terms and conditions? What sort of are the main areas?
I'd say the biggest point really is to make sure that there's no ambiguity or confusion. The agreement should reflect everything that's been agreed, and also the wording. Often the wording, even though you think it might say you think it might reflect what you've agreed, in reality, a couple of words might actually throw that off. So yeah, definitely make sure the terms are all set out as you'd expect them to be. There's obviously various aspects which are important in that regard. Obviously the termination provisions, exclusions, limitations, dispute resolution, which obviously Andrew will touch on later, and also not only the agreement itself, but any sort of post-termination provisions and restrictive covenants, things like that as well.
Okay. And I suppose, Andrew, I guess, however, the biggest real-world problem is often whether or not, or which terms and conditions are applicable, or whether or not you've managed to successfully have the relationship governed by the terms and conditions that you want. So it's all very well to spend a lot of money on a very long and effective set of terms and conditions, but they're of no use at all unless they're actually incorporated into the contract. So I suppose you've probably seen things go wrong on occasion.
Oh, well, Lauren was talking about if she's acting, she wants the contract to remove ambiguity. My role is to find ambiguity. If I'm acting for the person who's the subject of a claim, they're trying to get out of it. So my role is to go through the terms and find things that are wrong, loopholes, some way of getting out of it. And what I would say is to start from my side, is that there are no perfect terms and conditions. Even if we spend many hours, many pounds of your money, we're never going to generate a set of terms and conditions that will cover all eventualities. There's always going to be somebody like me who will be able to argue something and engaging me to argue things on your behalf. So you want something that is sensible and works at a price that is appropriate to your business. And what does go wrong? Well, there are a whole host of things that go wrong when people approach me. People's terms and conditions are often, shall we say, homemade. So a business has taken some clauses from competitors' terms and conditions, put a whole mishmash of them together, and then they rely on those as their terms and conditions. And often they just don't work very well together, or that as a cohesive whole, the terms just don't work. So comedy moments, I've had cases where I've been acting for a supplier of goods, and the supplier of goods has actually taken the terms and conditions of a buyer and use those as their terms and conditions. So it's completely the wrong side. They've got all the provisions to try and avoid liability in their own terms and conditions, which is obviously, far from ideal. The other point that I would make is that however good Lauren and Andy will make your terms and conditions, if you don't incorporate them into your contract, then they will not do you any benefit. Whichever side, whether I'm acting for the person making the claim or trying to get out of it, very often the point that I will have is whether the terms and conditions are actually part of the contract itself. So how can you make them part? Well, one, make the other side sign your terms and conditions. Two, as you often see people like recruiters do, have a click-through whereby you can't see something unless you've agreed to terms and conditions. But one way or another, you need to make sure they are incorporated. A classic example is where everything goes wrong. You've supplied goods to a company. The company becomes insolvent and you want your goods back. I've acted for many insolvency practitioners where your job is to look at whether the claim's valid or not. And claims are often not valid simply because nobody's incorporated the terms and conditions, and so they have no right to come onto premises and remove goods.
Which is normally something you'd put in if you're a supplier of goods. You'd put a clause in called retention of title.
Exactly.
That allows you to go, and if you haven't been paid, to go and get your goods back.
So you may have some nice fancy terms and conditions that say just what Andy said, that title remains with you until you're paid. If that's not incorporated, you can't use that as against an insolvency practitioner, liquidator, and try and get your goods back. So I think those are the ones I see all the time or often.
What happens if there's an agreement, oral or an email that seems to be to conflict with what's in the strict terms?
That's a good point. You will often see somebody will have some terms and conditions, and they will say that that's the entire agreement between everybody. And but what often happens in the real world is that, funnily enough, businesses talk to each other. They email each other, they write letters to each other, they talk to each other, and they will agree terms that are different, don't reflect exactly what the terms and conditions say. So I think what Andy's question is, well, where are you then? Is it the terms and conditions that apply, or is it what the parties have agreed? Well, there's no absolute answer, I think. But the more likely scenario is that if it went all the way to, God forbid, a trial, that a court is likely to look at what the parties actually said to each other and actually agreed with each other, and the court will find a way to say that there's been, say, a variation of what was agreed before, or what they've expressly said between themselves will apply. That's I think the general rule.
Lauren, how do you feel when you get a request to look at someone's terms and conditions that they've drafted already, and you get them in front of you? What things are you looking for?
I suppose it's different terms and conditions to the commercial agreements. So on the commercial agreement side, the first foremost thing to look at is who is on the other side and whether they've got the money and the means to supply whatever they're trying to say that they're going to supply. So, that's kind of a different thought process. But for the terms and conditions side, it's it's looking at kind of the size of their business and what they actually need. First and foremost, if we're going to be drafting them, we need to have a discussion and actually understand what their business does, how it works, what kind of goods or services they're providing, the delivery type terms, payment terms, all the kind of core essential aspects. But often people need to sit down and actually think, what do I do on a daily basis, and make sure that is actually reflected in writing, really.
I think so. I think people have this imagination that we just press a button and, there's a set of terms and conditions, or that you can just go and take them off the internet and that's fine. And it looks good because they look like they're a proper set of terms and conditions, and a lot of small businesses just want a proper set of terms and conditions to make it look like they're a serious business, and it helps them to sell, to have that as almost as a PR thing. But the answer is they can be very, very unsatisfactory indeed. And you can't just take a generic set of T&Cs. You're not selling widgets. You're always doing something. There's always a bespoke business need, even with terms and conditions, to make them tailored to some extent to your business. It's important to have that. I think that discussion with the lawyers drafting terms and conditions or looking at them. Otherwise, you won't really get the proper value that you're paying for, because you need to assist. We're not an expert in selling whatever it is that's being sold or services. So we need to. And the more we understand it, the more we understand the particular pitfalls that can relate to that matter, the easier it is to make sure that we're tailoring T&Cs. And I think one of the other risks is...
Well, sorry, I didn't mean to ruin your pitch.
My flow. I think the other thing to say is that if you make terms and conditions very long, because you can go and print off 30-page terms and conditions that no one ever reads, and part of the process is, people just agree to them because they won't read them, which is perhaps a bit cynical, but possibly true. But the other point about writing clear English terms and conditions for specific circumstances is that in reality, 95 or 99% of disputes about contracts don't go to the lawyers to litigate in court. Because it's very expensive. I mean, it's in terms of litigating small business matters, it is very often not cost effective to do so with the best will in the world. But what you want is a set of terms and conditions that if laymen can read them and understand them and they're clear on their face, you can pick the phone up when you're having the argument, and you pick the phone up to the other side when you're having the argument. When something goes wrong in a contract, or there's a non-delivery or there's a problem, say, look, you said you would do this, you haven't done this. And it puts you in a much better position when you actually pick the phone up for negotiation, and 95% of the time that actually is the use of having well-written terms and conditions that enables you to come to a quick and easy and sensible resolution. It's not in your favour and you're not over a barrel. You haven't got a set of terms and conditions that standard says that, if you've made any tiny alleged breach, they can sue you for the balance of a 3-year contract term or something. That puts you in a very weak position because you're quite scared to pull the plug on them and tell them to not give you any services anymore. Whereas if the cost of that is much less, then you're in a better negotiating position commercially. So those are some of the things you sometimes have to look at.
Yeah, and often it's useful to add in mechanisms. So say, for example, the price increases due to external factors, to have some sort of mechanism in the contract or the terms and conditions that allow that. A lot of the time, there'll be specific termination provisions which will apply to certain companies. So yeah, everything should really be kind of bespoke and thought about specific to that kind of company and what they do.
So just in my experience, which is obviously when things go wrong, it will be very often in a situation where there aren't any terms and conditions, or they're inadequate, and then a problem arises. And I will often say to the client, why didn't you get terms and conditions, or why didn't you get proper ones done? And the answer is always the same, that it cost money, it wasn't the right time in their sort of growth or development to look at it. And but what I would say to people is, don't wait till a dispute ends up with me and you're having an argument. When you're growing as a business, a point will come fairly early in your development when you need proper terms and conditions to safeguard against matters and to avoid disputes which can cost serious amounts of money. So I think obviously it's a cost. Nobody wants to incur a cost with lawyers, really. But it is something that may benefit you in the short term, the long term. It won't insulate you from all disputes. It won't, as I tried to say earlier, there's no perfect set of terms and conditions, but if you've got a set that function reasonably, you've reduced the risk and you allow yourself to solve your own disputes, as Andy said, and then you never get on my desk.
Because I suppose if something does land on your desk, often you'll look at them and think, oh, they actually are drafted quite well. Yeah. It will cost, a lot more money potentially if, rather than a sort of a poorly drafted set. Exactly.
If they're poorly drafted, then it probably hurts you probably more than it helps you. And the other thing to remember is that if you are, say, say a seller in a situation, you're selling goods and somebody really desperately needs them, then they may well be willing to sign your terms and conditions. So it's you've got to look at the commerciality of it all and use your power when you can to get your terms signed by somebody at the outset, if you can. And that will benefit you if it goes wrong. I mean, most times at the start of a commercial relationship, everybody's happy, pally, getting along. It's happiness on all sides. But I think it makes sense at that point to try and protect against it potentially going wrong sometime in the future, and try and sign people up to terms if you can, if you've got the commercial power to do it at that point in time.
I think one of the things I've come across a lot of the time drafting is that if you draft a set of terms and conditions that's too onerous, that's too pro, in this case, seller if you're acting for a supplier, then you'll get pushback from the people that actually read them. And if it goes to a lawyer, you'll get a lot of pushback. So what you don't want to do is be so aggressive necessarily, unless you're a large organisation. And large organisations obviously have potentially in-house legal teams and have all sorts of, they have terms and conditions of purchase as well as terms and conditions of sale. Usually they try to impose when they buy goods from suppliers. So that's a different scenario. But I'm assuming here that you're not a mega corporation with your own in-house lawyers who are listening to this, but an SME or an advisor to an SME. And I think one of the main traps that you can fall into is being too aggressive and putting ridiculous clauses or ridiculously pro seller clauses. It's handy if people just sign them and that you have a dispute and you've got those things. But on the other hand, you're going to get a certain amount of if these are commonly used T&Cs for significant values. At some point, somebody internal to the other side will look at them or even pass them to an external lawyer, and then you get pushback and you get costs trying to agree, and you might even lose sales if they're too aggressive. So there is a commercial balance in not having too long and too onerous terms, but you definitely want a position where you're kind of not just signing up to whatever the supplier's putting in front of you, and if you're the supplier, you don't want to be so aggressive that it puts buyers off.
And I think that's right. I think if there are circumstances, obviously, where you need a complete bespoke commercial agreement. You're doing a deal with somebody for a large amount of money, something very important, that requires not routine terms and conditions that you rely on for normal business every day. You need something bespoke, an actual bespoke agreement negotiated between the parties that will have all those clauses in. It might be lengthy. I think what Andy's saying, I think what I've noticed in his drafting over the years, is that there are many contracts where if the terms and conditions fit, say, a page and a half of actually bespoke to people's businesses, but they're not lengthy, then they're more likely to get through. They're more likely to be accepted than something where you're trying to sell something for just a few £1,000s and you send them a contract that's 20 pages long. Often people are wanting their terms and conditions to be on the back of orders, to be on the back of order acknowledgements, that sort of document. And usually that's around about, you can only get away with a page or so there.
Quite small font, to be fair.
Quite small font.
In columns.
Maybe some of it in bold types because you have to emphasise things. But but only say a page or so. And actually drafting that sort of document takes a bit of skill. You've got to try and remove the possibility that the likes of me will find huge holes in it. So it's actually a skill to produce something that's relatively modest in terms of the number of clauses it's got, but still works.
I think what's also a good compromise often is having like a front sheet which sets out the specific terms to, what the parties are after, and then perhaps having the terms and conditions, which are slightly more generic, attached to it. That's often, quite suitable for a lot of businesses as well.
Yeah, I mean, that's our standard. When we're drafting, we tend to have the specifics set out in the front sheet, and any special terms, a space for any special overriding terms or rules that are different to the normal position on the front sheet, and then the generic T&C is attached.
And then it can be used again, obviously, which is adding value to a company, really. They can, adapt it.
Use it again.
Different scenarios.
And I would suggest that once you've got your set of terms and conditions up, that you stick them on the back of a lot of the documents that you use day to day. So you send an order out, confirming that you've received an order. Stick your terms and conditions on the back of that. If somebody sends you an order and you're sending them an order acknowledgement or something, stick your terms and conditions on the back of that. Put them on the back of your invoices. I mean, just stick them on your commercial documents in the hope that if it all does go wrong and it comes to me, I can say, look, these are all incorporated into this contract. And I've got some chance of arguing that if you've got them on the back of a lot of your documents that you're using day to day.
Just a little point, not only on the back of your invoices, because that's too late.
Well, that is too late unless you deal with somebody over and over and over again, in which I'd still may have an argument for you. But Andy's quite right. To stick them on the back of orders, order acknowledgements is perfect, really.
I mean, technically, we were trying to avoid technical advice here, but obviously, in English law, any people who studied law know that it's offer acceptance and an agreement to pay consideration, whatever you want to call it, that trigger a contract, and anything that's agreed after the contract's been agreed, or anything that tries to be imposed by one party after the contract's been agreed, unless it's a variation of that contract by agreement, is too late to be incorporated. So one of the common problems, for example, in the retention of title clauses that Andrew was talking about, is that the only time that the person who ordered the goods ever saw the terms and conditions of the supplier was when on the delivery note or on the invoice, and that's too late to incorporate it. So the insolvency practitioner will just say you can't come and get your goods because that retention of title clause that you're trying to rely on, even though we've got your goods and even though you haven't been paid for them, you can't take them back because those terms and conditions came after the contract was made. So it's important to get the terms and conditions in their faces up front if you want to try to rely on them. I suppose we should also just briefly mention the default position if there's nothing and there's no business to business contract or business to business arrangement that isn't contractual in nature. If you've agreed to buy or sell something and there's a price agreed to be paid, that's enough for a contract. So there will be a contract, but quite commonly people say there's no contract when they mean, next week I'll take my car to Sean, my local garage repair man, and I'll just say, give it a service and MOT, please. And there won't be anything in writing that I sign, but there's still a contract. And actually, from the point of view of a seller, and a buyer, there are default provisions that come into play from the Supply of Goods and Services Act most of the time, and which says that somebody providing goods or services, the services have to be of reasonable competence and the goods have to be of a reasonable quality, those sorts of things. So, and that's in the case of a consumer laid with additional consumer protections as well. So there are some default provisions, but from a supplier's point of view, they're relative, that they don't give you some of the provisions that you'd like to see in. If you're a supplier, you really want to close the door on open-ended claims against you because of something. So you'd want to limit your liabilities. And it might be a good time, perhaps Lauren, just for you to say, what do you think the key clauses that you would look at, in individually? If I said, here's a 30-page contract, I know you're a business person, you haven't got time to put it in front of a lawyer, you want to look down it to find what are the clauses you look at to see where the traps are. What are the clauses you'd look at if you got a contract or terms and conditions in, just to see where the risks would be?
Typically, termination is a big one. Often, contracts will just have provisions which allow for one party to terminate and it'll be quite open-ended, the reasons why they can do that. Obviously, you'd want both parties to be able to. Often you'd want notice, or, if there's a material breach of the agreement. Termination is a big one. And
are we talking here about more about long-term supply of services rather than goods?
Yes,
goods will just be they turn up or they don't, I guess, usually.
Yeah. And obviously limitation on liability as well. So often you get, you'll have caps. They'll limit to sort of the value of the goods, or there'll be a specific figure inserted. And often, again, that's only one way. There's also indemnities that people try to throw in.
So what's an indemnity? Just for the listeners, what's an indemnity?
So an indemnity would be where if there's an issue, and you have to pay out for it, that you'll be paid, that you're sort of saying you'll pay pound for pound any amount that they incur, kind of thing. So that's another sort of big one. And often, depending on the nature of what your business is, IP can be quite a big contentious point, and whether the ownership of that passes, really. Again, that can be quite a big contentious point.
I suppose these are because of as a common misconception about intellectual property is that if you commission someone to produce something for you, such as a logo or a wedding photographer in that case, or a photographer for brochures, that you because you paid for it own the IP, but that actually isn't the case under the Copyright Design and Patents Act. Exactly. Under English law. Yeah. There's got to be an assignment of an actual written assignment of the copyright if you want to own the copyright in something. For example, copyright, of course, includes things like computer code. So if someone's coded something, you paid some external person who isn't your employee to code something for you, or to design something for you, or to take photographs or make video images for you, or sound recordings for you. In fact, the copyright of all of that it stays with them, and they simply license it to you. For a potentially limited period. That's, for example, in wedding photographers. If you look at their contracts, it's quite common that if you want to use the photographs for something else, or perhaps a business scenario, if you've got a brochure that you've got photographer has taken photographs for, they're only licensing you to use that in the brochure. And if you want to use it for other purposes, you'd have to go back and get another license from them or buy the copyright outright. So but especially with software, that can be very serious, because there's a lot of value in software if it's developed bespoke for you. And you need to make sure if you ever want to sell your company, it's software heavy, and that software is valuable and important to your company. One of the very first things a purchaser will ask is to see the chain of copyright assignments to make sure that you do own the company that they're buying does actually own the copyright in that software. And if not, then that can be a significant cost or loss of value to you. So those are the sorts of traps you need to be careful about, people trying to grab your IP. So if there's people are providing services to you in some sort of joint project, or they're developing something for you, be very careful that they're not grabbing the intellectual property rights out from under your nose when you're the person paying for it. So that's if IP is important at all in the contract, and what's being done, services being provided, it's important to have a look at that. I think the main risk with term and termination is probably the rollover periods. So check that if it's an ongoing service supply contract, make sure that initial period's not 3 years and it automatically rolls over for 3 years if you don't give notice, at a certain point. One of the things we tend to do internally is we often have standard terms and conditions that have a provision that says this contract will automatically roll over for another year or another 2 years or whatever if you haven't given notice by a point. But you can give notice at any time. So you just give notice on day one of the contract and give formal notice saying in 2 years' time, if this is a 2-year contract, in 2 years' time, this contract comes to an end, and we get them to acknowledge it at the beginning. And then we don't have the risk of forgetting a diary entry and finding we're bound to another 2-year contract with someone we might not be happy with, or might want to jack prices up and we can't do anything about. And that's, I think also a real risk. I think just in terms of stories, that the worst termination clause I ever saw drafted, the worst in terms of one way, was a long sort of 1 year, quite expensive contract. And there were lots and lots of different types of services that were being supplied by this large organisation, and that each of them had a separate start date and a separate contract for. And in the contract, unless you gave notice on the exact day required, you couldn't terminate the contract. You couldn't terminate it and it rolled over, which is incredibly nasty and sneaky. But it's there in the small print, and some lawyer obviously thought they could do it. But that's the reason. Sometimes you need to be very careful reading, making clear that you can terminate. I mean, the best contracts are ones that are for, ones that you can get out without having to show any damages or cause called termination for convenience on a relatively short time period. So if you're just not happy with the service, you can terminate and just walk away. That the ideal clause to sort of have in is one where you can just give a reasonable notice and walk away. But you need to be careful of the duration clauses, and I think certainly the other ones are limitation clauses. And I think that's something that's there's usually two types of limitation clause, and I guess the first is just a cap. The total damages you need to pay to the other side won't be more than X pounds or X percentage of the value of the contract, effectively, or the annual value of a contract if it's a rolling annual contract. And they're very, very common, and you can see why they're in. But you need to bear that in mind. If someone's providing you a service that is very valuable to you, or if it goes wrong could cost you a lot of money, you have to understand if you're signing up to a cap that there's that risk gap. And the other one is the types of damages that can be claimed, and usually they're sort of more remote damages or reputational losses or speculative damages are excluded, and that's usually fine. But again, you have to be careful. It depends what service is being supplied. For example, if there's a provision in there that says we're not liable for data loss, and what they're doing is actually providing you with software services for your database, then that's not a reasonable clause to have in, because the core of what they're providing to you is data manipulation and making sure that it doesn't get lost or corrupted.
But obviously, from my perspective, as I think I said at the start, my aim is to find ambiguity if I'm trying to get somebody out of a contract, to try and less what they have to pay. Things I will often look at is the termination provisions. They're often what is in play when something gets to me. And I think good advice to most businesses, unless you're arguing over a very modest amount of money, is to take advice as to whether you're entitled to terminate. If you are entitled to terminate, then perhaps you might at least ask a solicitor like me, how much would it cost to draft the termination letter that will give you a better chance that it works and is appropriate. Certainly if you're in the world of landlord and tenant, if you're looking to terminate, then you really, really ought to take proper advice. There's all sorts of old cases about what's appropriate notice, even what coloured paper notice was served on, I think, in times gone by. The other one, perhaps just that I would always look at, and which the other two haven't, probably because it's just not so relevant to them, is that I always look, what's the law that applies to the contract, and what courts will decide the disputes that relate to the contract. Now, a modest war story is that I have seen a contract for a company that only supplied within England and Wales, where the law said to apply in their standard terms and conditions was German law. Because they'd they copied some terms from somebody else, put them in their terms and conditions, and that was effective. I mean, it may sound a bit mad, but it just doesn't help.
And Lauren, I suppose if we had, I think, to wind this up, if you had to give the listener sort of 5 takeaways for whatever number you like, but pick five takeaways from this topic, what should they bear in mind when thinking about or looking at terms and conditions?
So number one, I'd make sure that they properly reflect the commercial terms which have been agreed between the parties. 2, I'd make sure that they're not overly drafted in favour of the other party over you. So make sure that, lots of the clauses are mutual, do apply to both parties. And also, for example, if you know that you're going to have a reorganisation coming up, it wouldn't be sensible to have change of control type provisions in there. So yeah, to reflect the reality of what your company is and what's going to happen in the future, so far as you're aware of that. Definitely 3, to limit your liability for breach. So you want to sort of limit any indirect losses as far as possible. So consequential losses, they can be quite expensive and quite extensive. 4, I'd say, check the termination clauses, make sure that you can terminate early if that's something that you need and you want. And also in the event of, say, insolvency for if the other party become insolvent, or if there's a breach, you want to be able to have that ability to get out of the contract. And finally, 5, I'd what I probably would say is quite a useful clause as well is to have some sort of dispute resolution clause, which says in the event of a disagreement that perhaps managers, CEOs, whatever, they'll discuss the issues first and foremost before sort of engaging in any external assistance, because often just sitting down together, that can alleviate a lot of issues, and it can also be important for the ongoing relationship, the business relationship that the companies have with one another. So yeah, I'd probably say they're the 5 kind of key things to look out for and be aware of.
Okay, thank you very much. I suppose just coming back very briefly to Andrew's comment about getting him to give you advice on whether he can terminate or not. I think probably one of the main issues with that is if you think you're entitled to terminate a contract but aren't and get it wrong and then purport to terminate the contract, it's you that become in breach of the contract and possibly under the terms liable for horrendous damages and losses. So that's why it's very dangerous to terminate a contract unless you're absolutely sure you're entitled to terminate the contract. And it's still better to do it if it's a significant value contract and therefore you're exposed to significant losses if you're in breach of it, or damages if you're in breach of it, then you should definitely have somebody like Andrew have a quick once over to make sure that it's the right thing to do.
And following that's absolutely spot on. You can go from being in the ascendancy in a dispute to very much on the back foot if you purport to terminate when you had no entitlement to. You could have done other things to improve your position, enable you to properly terminate, and then you're in the ascendancy. So that's important. That's why I say I'd take advice on that. In terms of my takeaways from this, would be and it goes back to something I think somebody said earlier. Business to business, lots of people approach me and say that they haven't got a contract. Chances are they have. I mean, there's if you've done a deal, you'll have a contract of some sort. I will then want to know, what is it? I'll be looking at, is there any writing, text messages, emails, and so on? If that's all you've got, then that produces ambiguity. Much better to have a set of terms and conditions which you're seeking to impose at the outset and which can be relied upon if things go wrong. There's no perfect set, but they at least give you some place to start. And then I think that people should bear in mind that there are certain deals that businesses do where you need a bespoke set of terms, not just relying on standard terms. You need to set it out properly in a fully drafted contract that has all the bells and whistles that it needs, so that when it gets to me, there isn't so much ambiguity that I can't then deal with the enforcement of it if needs be. So it's horses for courses. I would always advise somebody to have some terms and conditions, but don't rule out the fact that sometimes you just need a fully documented contract, because the risks of not having one outweigh the cost, frankly, of preparing it. That's it from me.
Thank you very much. Pleasure.
Thank you. Thanks.
So I hope you've enjoyed this podcast, and please do check out other ones in this series.